In a lawsuit, there's a period of time that's called the discovery time. Now, what is discovery? Well, think of it this way. The Discovery Channel. What does the Discovery Channel involve? They're looking for information and trying to find answers to questions. Well, that's the same thing it is in a lawsuit. The other side is trying to find out information from you. You are trying to find out information from them so that the facts can all be put together to figure out what happened in this situation. Who's at fault? What injuries occurred? How much is this case worth? Does this case need to go to trial? And all these things play into it. Now, there's a couple of different methods of discovery that are used in most personal injury cases. There's going to be things called interrogatories. Now, that's a kind of a big word, but basically what it means is written questions. And so they're going to send you a written question that you're going to answer under oath. Your attorney is going to send them interrogatories where they have to answer questions under oath. There might be a thing called a request for production of documents. Well, what does that mean? That means that the other side wants documents to support a particular thing. They'll say, I want documents about your medical care, or I want documents about your loss of earnings, or something of that nature, or what injuries you had, or they want pictures, things of that nature. So each side's going to exchange the documents. There might be something called a request for admissions. In other words, do you admit, Mr. So-and-so, that you caused the accident? Or do you admit that you had a pre-existing condition? And so each side is exchanging information so that there's no surprises down the road. Other types of discovery include things like a deposition. And again, another big word. This is where the other side asks an opponent or a witness questions face-to-face with a court reporter. That testimony is under oath, just as if you were sitting in trial giving your testimony before a judge and a jury. A couple of other miscellaneous ones are an inspection of property or a medical examination, things of that nature. But basically, the point of discovery is to exchange information so that all sides know the facts of the case. Very seldom do cases involve like the Perry Mason scenario where Mr. Witness, I have out of my pocket this document, because they've already exchanged it. Everybody knows what the other side's going to have. And that really helps us settle cases because we know the facts before we walk into court. Now, there might be a discrepancy of a witness's opinion or a witness's perception of an accident or something like that, and that makes it a little more difficult. But we know that through discovery. So it's an exchange of information to find the facts. That's what discovery is.